Now, private early childhood development centres may reopen immediately. It's a ruling just handed down by Judge Hans Fabricius at the High Court in Pretoria. The case against the Department of Social Development was taken to the court by the trade union Solidarity. Let's speak now to attorney Antonie van Wyk, who represented the South African Childcare Association in this particular case. Good afternoon to you. Thanks for joining us. Why did this go to court in the first place?
Jeremy, there was much uncertainty in recent times about the legal position of the ECD sector. There were a number of communications and letters from the Minister of Social Development, which indicated that ECD centres would not be allowed to reopen. But on an interpretation of the regulations, that seemed to be not a valid position from a legal perspective. In addition, the Minister of Basic Education had indicated that the grade R and at some point pre-grade R schools could reopen. There is a technical overlap between the Basic Education Department and Social Development in terms of that segment of schools. So the purpose of the court application was to bring clarity.
I want to know, given this court decision then, it means an immediate reopening, but what guarantees are there that the centres themselves are going to be ready in terms of all the necessary protocols that have to be implemented? How is that going to be managed and determined?
We don't know. One of the difficulties that has faced the Minister of Social Development is that she doesn't really have a control over the industry, the ECD sector. By far the majority of nursery schools and partial care facilities are literally not on record. And there's a backlog of catching up with the putting them on a database and getting information. The Minister has published self-assessment forms and standard operating procedures for facilities with a view to reopening. The only thing that was missing was a date of reopening. So they have the tools at their disposal. The reality is that it's impossible for the ministry to go police that and to establish whether these unregistered facilities are actually complying with these provisions. Hence, I imagine the reason for the self-assessment form, etc. So that has been a big challenge in this sphere in recent times.
It's more than a big challenge, isn't it? It's fraught with danger. It puts hundreds, if not thousands, of children at risk, surely.
Well, what puts hundreds and thousands of children at risk is the fact that they, at the moment, do not have care. So a lot of them have relied on the ECD sector for food and for care. So, which has been a major argument in the court case, is that the children have been suffering, have been traumatized because a lot of them have been left at home without any care. A lot of them are reliant on the ECD centres to provide them with the nutrition that they need. Literally, that's the only meals that a lot of them get. And they haven't been receiving those meals and that support. So the other point as well, which is very important, is that professionals seem to, across the board, support the view that children of that age are not at risk really of contracting the disease. They don't transmit the disease as readily as adults, and they're not at risk of, not a very high risk from a medical perspective, which made it so irrational for the, with respect, for the minister not to proceed with the reopening in parallel with, gathering all other information that may be required and insisting on the appropriate protocols, etc.
Okay, thank you for joining us. That is Antonie van Wyk, who represented the South African Childcare Association.